I welcome you to this program of the ICSI IIP on the various issues under the Insolvency and Bankruptcy Code of India. The enforceability of arbitral awards in insolvency proceedings has always been a subject matter of contention after passing of the IBC 2016. The Indian economy has seen a rapid increase in the number of high-profile insolvency cases. The Insolvency and Bankruptcy Code of 2016 was brought in to regulate and bring a set mechanism for the resolution of insolvencies with the intent to prioritize and a delicate balance for all stakeholders in a time-bound manner. There is no doubt that the code has enhanced the due diligence which is followed in the process of insolvency. The interaction of arbitration and insolvency has always been at loggerheads in the judicial interpretation. When the corporate debtor is the subject of the corporate insolvency resolution process, there may arise issues regarding the arbitrability of disputes and enforcement of awards by the award holders. No doubt, India's ranking in the ease of doing business has increased during the last few years, and it has been appreciated all over. But the fact remains that so far as the contract enforcement is concerned, we have not appreciably improved our position. It is also a fact that after passing of the 2016 Act, the insolvency resolution process has become much easier, and wherever there were difficulties, the law has been amended by the Parliament. But it also goes without saying that IBC is still a work in progress. Issues which still remain unresolved, and enforceability of arbitral awards and insolvency proceedings is one such issue. Further, the Insolvency and Bankruptcy Code 2016 does not differentiate between the arbitration proceedings which are pending and the one which commence after the initiation of insolvency proceedings. The courts have, however, in an attempt to provide clarity, have opined that it can be demonstrated that arbitration is initiated for the benefit of the corporate debtor to maximize the debtor's assets, or that the arbitration proceedings will not adversely affect the corporate debtor's assets, an arbitrating party may be able to successfully plead the continuation of the arbitration proceedings. Again, the IBC was introduced to consolidate and amend the law relating to reorganization of insolvency resolution of corporate process. And on the other hand, the Arbitration Act was promulgated to consolidate and amend the law relating to domestic arbitration. Therefore, both these statutes are separate statutes that operate in different fields of law. However, Section 238 of the IBC give an overriding effect to it over all other statutes, and in case where the underlying debt relate to the contract where parties have decided to submit their disputes in arbitration, an overlap between arbitration and insolvency proceedings may arise. As you may be aware that the Supreme Court has explicitly stated that insolvency disputes are not arbitrable even when there is an arbitration agreement between the parties. In the case of Booz Allen and Hamilton versus SBI Home Finance Limited, thus while recognizing the mandatory duty imposed under Section 8 of the Arbitration Act, the Supreme Court stated that where the dispute is not arbitrable, the court should refuse to refer the parties to arbitration, even though the parties have agreed upon arbitration as a forum for settlement of the dispute. We should not lose sight of the fact that insolvency process is a time-bound process that endeavours to revive the distressed companies and does not offer a recovery forum. Insolvency proceedings are proceedings in rem, impacting the public at large. However, in a recent decision, the NCLT, in the case of Kotak India Venture versus Indus Biotech Private Limited, has referred the parties to arbitration during the pendency of insolvency proceedings and dealt with the pivotal issue of which statute prevail in case of conflict. Relying on the age-old principle of special law prevailing over general law, the NCLT has held that in case of contractual dispute between parties, when an arbitration clause, arbitration would prevail over insolvency proceedings and prevent solvent companies facing CRP. The arbitrability of insolvency petition still remains a gray area with no clear answer due to contradictory rulings and lack of a Supreme Court ruling on this issue. Therefore, I am of the considered view that let the different rulings which have come either from NCLT and other forums, examine it properly in our institute and as well as by the insolvency resolution professional, and await for a final decision from the Supreme Court to get a more clarity, or alternatively, maybe the Parliament itself can take a lead by making certain provision under the law clarifying the position in this regard. Thanks for your attention.